Welcome to Oil and Gas with Energy Law Prof. We're going to talk about pooling today. We're talking about how Texas eventually implemented pooling to deal with owners who owned less than was necessary to drill a well under the normal spacing rules. And we'll talk about how pooling is used in other states to address the same issue. So Texas eventually realized maybe it meant more sense rather than simply having each party drill a well on his or her own land, no matter how small, instead to have landowners come together to drill a single well and share the oil and gas. In Texas, the Mineral Interest Pooling Act, which was passed to accomplish this purpose, only applies to fields discovered after 1961. So there's no forced pooling in old fields. And keep in mind, that's pretty similar to that Port Acres case, which ended living allowables for fields discovered after 1962. So there's a big change that happens in Texas law for dealing with these small areas for fields after 1962. One, no more living allowables. Two, then you have forced pooling under the Mineral Interest Pooling Act. And we'll explain how that works. So to use the Mineral Interest Pooling Act, first, you have to try to pool voluntarily. So first, you have to try to reach an agreement with your neighbors and the oil and gas companies operating their land to pool the products from a single well. Secondly, if they don't agree, then you need to go to the Railroad Commission and ask for a share in production from the well, and the Railroad Commission is going to have to say, you made a fair and reasonable offer to your neighbor, and the Railroad Commission is going to be looking for that before they're going to force your neighbor to share with you. So bottom line, if the parties can't work out a deal for themselves about how to share production from a well, then the state may, but only as a last resort will it resort to that kind of forced pooling where it forces one landowner to share with another. So we've already talked about some of the reasons why you might pool land together to produce oil for several neighbors from a single well. For one thing, it can be much more efficient geologically. We talked about how it can be a very bad idea to drill lots of holes in a single reservoir that reduces reservoir pressure. It may make a lot more sense to drill a single well to produce from that reservoir. Secondly, it can be a lot more efficient in terms of business efficiency. Rather than spend the money on several wells, just spend the money on a single well. Note that this is typically much more important to the oil and gas companies, those lessees, rather than the lessors, the actual landowners. Because the landowners are typically compensated with a royalty. So the landowner typically thinks the more production, the better, no matter how much it costs to get it. Because they get a share of the production, they don't care what the costs are. The oil and gas company has to worry about those costs and so may prefer pooling because it's more efficient to spend money on a single well, especially if it's going to produce just as much oil as two wells would combined. Finally, pooling is sometimes necessary to drill even a single well, because if the spacing rules say you need 40 acres to drill, well then bring all that acreage together to drill the single well. Note that that's very important, not just to the oil and gas company, but also to the landowner, because if they're not going to get a well without pooling the land together, then they're not going to get a royalty. So both the landowner and the oil and gas company typically care about that. Now, how do you actually pool? Well, the most common way is voluntary. So everybody agrees to that pooling. And actually one way that those voluntary agreements are made is through delegation to the oil and gas company. So usually the lease that a landowner, the lessor, signs with the oil and gas company, the lessee, will give that lessee oil and gas company the right to negotiate to pool that land together to make sure that they have enough land to drill a well under the spacing rules or otherwise. Sometimes the lease will say it can only be pooled to comply with the spacing rules, and the oil and gas company is not allowed to pool if it's only to avoid drilling too many wells. And we'll see some cases about that in the future. Okay, a third way that sometimes land is pooled together is through a community lease. We'll talk about those in the future. Typically, that's where you have a lot of very small landowners. It might be a suburban subdivision, and it's really not worth the time for all of those landowners to sign an individual lease and then at the end pool it all together. And so instead, maybe a whole neighborhood will sign a community lease. And we'll see that in Texas, that means probably that property is pooled together. Now, finally, the state can force you to pool because it believes it's necessary to protect the reservoir, to ensure that a well is drilled, to prevent confiscation, etc. And we'll talk about a case where the state was asked for a compulsory pooling, and that's Carson versus Railroad Commission. It's on page 742 in your textbook, the 8th edition of Lowe et al. And it is a case where actually an oil and gas company offered to pool in with a single party that was one of its lessors. So effectively what's happening here is that the oil and gas company has taken leases from a bunch of neighbors. And the oil and gas company ends up producing wet oil on one of those neighbors' lands. And you can imagine, what are those other neighbors thinking at that point? Well, they're thinking, it's great for my neighbor Carson, but it's really bad for me because the oil and gas is being pulled up from my land. And so can we have a share of that production as well? So BTA, the oil and gas company responsible for production on these neighboring lands. And remember, we've already seen cases like this, and it's very common that an oil and gas company would have the leases on neighboring lands. BTA says, okay, I know it's fair. Let's do what we normally do. Let's each have a share of production in the well based on our acreage. But Carson says, no. You already drilled a well on my land, and it's producing oil and gas. Why should I share with my neighbors on an acreage basis? I have the advantage here. BTA actually went to the Railroad Commission and got a forced pooling order saying that, yes, that acreage basis was reasonable. But what we see here is the Supreme Court of Texas says, well, that's not really reasonable because this is a little bit of an unusual situation where this isn't beforehand, before anybody knows where the oil and gas is. Then it might make a lot of sense. Everybody, let's go in together on an acreage basis. If you have 10 of 40 acres, you should get 1/4 of the landowner share. But the Texas Supreme Court says, well, this isn't anymore a priori before anybody knows where the oil and gas is. We already know all the oil and gas is being produced on Carson's land. Sure, maybe it's pulling up from under the neighbor's land, but that gives Carson an advantage that has to be considered when we think about what is a fair and reasonable offer under the Mineral Interest Pooling Act. So I want you to think about a couple things about this case. It's pretty interesting because, remember, normally all these landowners are going to expect at least their acreage share. So then how is the oil and gas company supposed to ensure that Carson gets more than the acreage share? Likely that's coming out of what would normally be the oil and gas company's portion. And so effectively, the oil and gas company here messed up by not doing the pooling before it started drilling and found oil. So what the Texas Supreme Court is saying is fairness is determined from the standpoint of the offeree, the person that's tried to be forced pooled, the person that you're trying to force to share the oil at the time of the offer. So maybe it would have been fair to make this offer to Carson before oil had already been discovered on Carson's land. It was no longer fair at the time the offer was made. The courts are going to also require serious good faith negotiations by both parties before they're going to allow the Railroad Commission to force a party to share its oil and gas. Small tract owners get favored a little bit here. So generally, compulsory pooling is going to be on an acreage basis. But what that really means is that those landowners are typically going to get at least their acreage share. And you can see that in this case, BTA versus Carson. Carson was able to insist upon more. Railroad Commission could also decide that in some particular circumstance, acreage basis would not be equitable. And it's important to remember that non-consenting owner share is going to have to be at least that acreage basis and possibly, as in Carson, somewhat more. Now, when the Mineral Interest Pooling Act was developed, the typical case that was thought of was the muscle-in pooling. And muscle-in, you can think about, crowded buffet table. If you want your share of what's on the buffet, you got to muscle your way into that buffet. Sharp elbows, maybe, to get your share. And so the idea is, if you have a small tract, so you can't drill, especially if you're not allowed to get an exception because of the voluntary subdivision rule or otherwise, and that landowner who does have the well, remember that Pickens versus Ryan case, and won't share with you voluntarily, then under the Mineral Interest Pooling Act, you're going to be able to muscle in to that unit to get your share of production. You say, please give me my acreage share. If they don't do that, you go to the Railroad Commission and say, I made them a fair and reasonable offer. They rejected it. So that's what a muscle in works. And that's the way that historically pooling often went. You can see some examples in the book of what might make the offer that you made to have a share unfair and unreasonable in the view of the Railroad Commission and the courts. But I also want you to think about how this is changing a little bit with fracturing and production of tight oil, which, remember, is production of oil from these layers where it's impermeable and it doesn't flow very easily. Because historically, it was typically the landowner that was left out that wanted to pool with a party that had a well. The party with the well was perfectly happy not to pool because the party with the well would continue to get all the oil and gas. And under the rule of capture, it would belong to the party with the well. That's changed a little bit with production from impermeable shale reservoirs, because sometimes it might be the case that to access all the oil and gas under a tract, in a conventional reservoir, you just drill straight down and pump it all out. It's easy. But with fracturing, you actually have to drill under those neighboring properties, usually if you want to produce oil and gas from those properties. Certainly if you want to produce all the oil and gas from under their property. Now, we know you can't do that normally. That would be a slant well. But of course, if you pool in, you can. And so that's changed the dynamic. So sometimes with fracturing, directional drilling and fracturing, the party that actually has the well wants to pool in a party that's not yet participating because they want to be able to drill underneath that party's land, which would be a trespass if they weren't pooled into that well. That's particularly the case if you have two close neighbors but not neighboring, and there's a party in the middle that isn't part of that well. They may want to force pool in that neighbor. So forced pooling has grown more common in some cases with otherwise non-participating owners because of the challenges of directional drilling and producing all the oil from these impermeable shale layers. Other states basically caught on to the idea that pooling was a better approach than a million exception wells much earlier. So other states have broad pooling, and they allow that conservation agency to pool the tracts even if some owners don't want to be pooled. So it's forced pooling. You can think of it like zoning. There are just some limits on your ability to operate your property just how you want. They typically do not make exceptions for small tracts. And so we can see, actually, if you look back at that Larson case, you'll see that they describe pooling just as a matter of course for those 80-acre tracts for drilling. Now, typically, any owner in the drilling unit can demand pooling, sometimes the agency can just do it of its own initiative. Now, it's important to also understand how pooling works financially, because remember, it works pretty well if all the parties have already leased to an oil and gas company. So the oil and gas companies can share the costs, share the production, make sure everybody gets their royalty. But what if you have a landowner who hasn't leased at all and wants to pool with a party that's leased? Well, the problem with that is, let's imagine that they want to pool and share on an acreage basis 50-50 in a well. Well, in theory, what that should mean is that party that's joining that doesn't have an oil and gas company should have to pay half the cost of drilling that well. that would be called participating. That would be, so you would actually be paying for the well, and then you would get half of the production, just like the oil and gas company does, and there wouldn't be a royalty. Problem, of course, is that most landowners don't have that kind of cash sitting by to just finance half of an oil and gas well. So often, instead, they ask to be carried. Now, being carried means somebody else pays your costs. And it can be a great deal because if there's no oil and gas in the well, you don't have to pay back that party that went ahead and drilled the well. And remember that historically, only about 1 in 7 wells hit oil back decades ago. And so that meant that, being carried was great. There was a big risk being paid by the party that paid its own share and paid your share. And if they didn't find anything, well, you were carried. You're not on the hook for it. If they did find something, then that other party who put up your costs would get paid back for your costs. But after your costs were paid, then you get your full half or whatever acreage share in that well. And so basically you take no risk, but you get to share in the full reward. Some states, as we'll see, instead require that unleased landowner to basically sign a lease with the participating parties so that instead of getting that, having its costs paid for it up front, it will instead get just that royalty share. Now remember, historically, that royalty share was only 1/8. And so you can think that's a lot less than, you're getting 1/2 of 1/8, your share of the landowner royalty. So that's a lot less than getting 1/2 of the full production. We'll talk about some of the bad incentives that it created, this practice of carrying the pooled party. One is already previewed on this page, which is the idea of a risk penalty, which says rather than paying back the party that put up the costs, you actually have to pay them back initially and then pay them some multiple of their costs to compensate them for the risk that they were taking in carrying you and paying your costs. Let's think about an example of how complex this can really be. So imagine that all this area, it's 160 acres, needs to be pooled together for a single natural gas well. Imagine that Iomi Oil actually already has a lease on the majority of this property. So Iomi Oil has a lease with A, B, and D already, with A, with B, and with D. So 100 out of 160 acres are already leased by Iomi Oil. Iomi Oil has the right to produce it. Now C, unfortunately, has leased to another party, to Blackmore Gas. E and F are not leased. Okay, so Iomi Oil has leases on the majority of the property necessary to drill a well. Blackmore Gas has a lease on a quarter of the property, and just 20 acres, so 1/8 of the property, are unleased. So what can Iomi Oil do to get the full 160 acres together to drill a natural gas well? Well, there are a couple options. So one option is that it could go ahead and lease from E&F. That would be very convenient because then it would have the 120 acres leased, so it would be much closer. It could enter into a farm out with Blackmore Gas. Now, a farm out is a kind of agreement that allows a company to say, you know what, I don't need this lease anymore. This other oil and gas company can have it. In return, just give me a share of your production. So that would be, we've talked about it before, an overriding royalty, a royalty that's created out of the lessee's leasehold interest. And so Blackmore Gas could say, you know what, just give me 1/16 of production. You can produce this and produce the rest. So that would be a way for Iomi Oil to then have the full property. Another thing that Iomi Oil could do, this will be a little less helpful, is it could take a top lease from C directly, so kind of cutting out Blackmore Gas. The way that would work is leases expire if they're not produced. And so if Blackmore Gas didn't produce that lease in time, eventually it would expire, and so Iomi Oil could get the lease after that. And you can actually pay a party a little money to say, I want the lease if it expires, but then you have to kind of wait for it to expire. Maybe it won't expire if Blackmore finds another way to produce. That might not work great, but it's a possibility. Okay, finally, another option would be for EOMI Oil to work with all these parties together in a joint operating agreement. A joint operating agreement is in some ways like a joint venture, or kind of even a little bit like a partnership. But if you learn about joint operating agreements, you'll realize nobody who ever wrote a joint operating agreement would want it to be interpreted as a partnership or as a joint venture, because that comes with a lot of default legal duties that they're specifically trying to avoid by writing a different kind of agreement, which is a joint operating agreement. But basically it says, let's pool money, operate this together, and share the profits of it. So that's what makes it seem kind of like that regular joint venture. So that's another option. Now these kinds of agreements, joint operating agreements and farm outs, are two kinds of agreements that are explored in depth in the oil and gas contracts course, and they're in the later chapters in your book that we won't cover in this class. So they're kind of more advanced oil and gas contracts. We'll hear about them again future in this class, but we really won't cover them in depth. But just keep in mind, they are ways for EOMI Oil to try to manage this challenge of different parties wanting some control over this well. So in these different scenarios, how would the cost of actually drilling a well be paid on this 160-acre unit? Well, under this, one option is that EOMI Oil, if not all these negotiations fail, could seek forced pooling from the State Conservation Commission and say, you know what, this should all be operated together. I've tried to negotiate with these parties. Let me operate the well. I'll ensure everybody gets their share. State Conservation Commission could decide that it should be developed and name one party the operator. In this case, that's almost certainly going to be EOMI Oil, because EOMI Oil already has the lease on the majority of the property. Now, those other interest owners can decide, do they want to participate in this by paying our costs up front and sharing in the benefits? It could be through a joint operating agreement or otherwise. Do they want to be carried? So have EOMI Oil pay their costs for them. If so, likely they're going to have to not only pay EOMI Oil back from production, but also pay some kind of risk penalty. Or third, could those unleased owners like E&F say, you know what, we just want the normal relationship with an oil and gas company, EOMI Oil, we're happy to lease with you for the same deal that you gave to the parties A, B, and D. Now, in that example where you have forced pooling, if everybody agrees to participate, everybody agrees to pay their share, so they'll get the full share of revenue, then EOMI Oil would pay its 100 out of 160 acres. So it would pay in that, right? That's basically 5/8 if you reduce it. No need to if that sounds complicated. But they're paying 100 out of every $160. Blackmore would pay 40 out of 160, so 1/4 of the cost. E would pay 5 of 160, right? 1/32 of the cost. And F would pay 15 out of 160, 3/32 of the cost. So believe me, that all adds up to 160 together, 160th, or 1. So that would end up paying the full cost. Now, the other option is that those parties could be carried. So let's say that E&F, they're individual landowners. They don't want to lease to EOMI or to Blackmore. And so they say, you know what, we'll be carried. And the advantage of that for them is they don't have to put any money up front. If it's a dry hole, they're not going to have to pay back EOMI Oil, but there may be a risk penalty. So maybe the state has a 300% penalty and they say, you know what, you didn't take any risk, E&F, so EOMI and Blackmore get to recover not only 100% of the cost that they paid for you, they get to recoup 200% more, so 300% in total before you get anything. And so because you didn't take the risk, you don't get the full share, but that still may be worth it for E&F, because instead of getting their their basically fraction of a 1/8 share, and it's a pretty small fraction, right? We talked about just 1/32 with E. Then so it would be 1/32 of 1/8. Instead, they get their full 1/32 when those costs are paid back. So sometimes it can be worth it to be carried even if there is a risk penalty. If there's not a risk penalty, it can be a particularly good idea, and we're going to talk about a case where that was initially the case, which is Benyon versus A&R Production. This is on page 755 in your 8th edition text. It's from Utah. It's from 1991. So Benyon's land was spaced by the state of Utah. The state of Utah orders a well drilled. It's not on Benyon's land, but Benyon gets a share. And Benyon says, I don't want to sign a lease, and so is treated as an unleased owner and is carried. So someone else pays the full cost, and Benyon receives the full share due to Benyon's acreage. So there's no penalty. So as soon as the costs are paid back of drilling the well, Benyon gets the full share. Now, when the state authorizes a second well, the state says, okay, you know what? The people that actually drilled the well, even after they've recovered their cost, they're going to get another 175%. So you can think about it as 275% of their cost. They're allowed to recover that because they're taking all the risk of paying it, and Benyon took no risk. Now, Benyon says, wait, I like the first deal better, and brings statutory and constitutional challenges to this, but the court upholds the statute and says, no, this is reasonable to compensate the parties that actually paid the costs. All right, one more early pooling case, Anderson versus Corporation Commission. This is an Oklahoma case from 1957, page 765 in your book. Remember that just like the Railroad Commission in Texas is the oil and gas regulator, the Corporation Commission in Oklahoma is the oil and gas regulator. So in this case, there were 80-acre spacing units. It pooled together the interests of different owners. Anderson refused to participate in the drilling, said, I'm not going to pay for drilling. Now, rather than force a risk penalty on top of the cost of being carried, the agency says, no, we're forcing you to take what's basically a lease. We'll give you a bonus up front and you get a royalty, but you're basically going to be treated like the other landowners that leased their land. You don't get the special deal of being carried and then getting the full value minus your costs. This is an Oklahoma-style forced pooling where you force somebody to do basically a lease. So it basically puts that pooled landowner in a very similar position to somebody who actually leased their land to begin with.